I'm Elizabeth Slattery, and welcome to SCOTUS 101, where we break down what's happening at the Supreme Court, what the justices are up to, and other things related to our favorite branch of government. This week, I'm joined by Mark Walsh, who writes for SCOTUS Blog, the ABA Journal, and Education Week. It's been a while since your last appearance on the podcast, so Mark, welcome back.
Always happy to be here.
So it's been a busy week at the Supreme Court with the justices issuing one pretty big opinion, orders, hearing oral arguments, and then there's the dust-up between the Chief Justice and Senator Chuck Schumer. So first up, we'll hit the highlights of the court's opinion in Kansas versus Garcia. It was a 5-4 ruling with the majority decision written by Justice Alito, split along sort of traditional ideological lines. The court held that federal immigration law does not preempt a state law criminalizing identity fraud based on information provided on the I-9 employment verification forms. So here, 3 illegal aliens were convicted of identity theft in Kansas for fraudulently using other people's social security numbers on state and federal tax forms and on the I-9 forms. This went all the way to the Kansas Supreme Court, which overturned their convictions on the ground that the Federal Immigration Reform and Control Act expressly preempts state identity fraud laws. It held that a state could not use information contained in the I-9 form as a basis for state law prosecution. So the state of Kansas asked the U.S. Supreme Court to review that decision, and the U.S. Supreme Court issued its ruling this week. Reversing the state Supreme Court, the court said that the state court had read the federal law way too broadly. It said its reading is flatly contrary to standard English usage. The court explained that although a tangible object can be contained in only one place at a time, an item of information may be contained in many different places. So accordingly, the federal immigration law did not expressly preempt state identity theft laws. The court also held that the federal law did not impliedly preempt the state law because the state law did not conflict with the federal law, and the field covered by the federal law is unrelated to the submission of tax forms. Justice Breyer, joined by Ginsburg, Sotomayor, and Kagan, concurred in part and dissented in part. And although Breyer agreed that there was no express preemption, he believed that there was implied field preemption. He viewed the field broadly as policing fraud committed to demonstrate federal work authorization. So, Mark, any insights on that ruling?
Well, I just thought, this case is kind of a relatively low-key case of the term, and then this week it's probably getting lost in a lot of bigger stuff. But I thought I'd point out an interesting passage from Justice Alito I thought was almost Kagan-esque in his use of some examples. He talks about supplying information if you go to a website to buy shoes and how that might get shared, and he even talks about a student looking up information on the moon landing, and one of his clerks had to look up Neil Armstrong's hometown newspaper, the Wapakoneta, Ohio Daily News. And then he said, suppose that an elementary school student writes a report in which she states that the first man walked on the moon in 1969. No one would say that the student used information contained in the Wapakoneta Daily News or another newspaper if she never saw those publications. Justice Alito using some interesting examples to bring the opinion to life a little bit.
So turning to the orders, the court granted cert in 3 new cases, which we'll just very briefly touch on. So the first is U.S. Fish and Wildlife Service versus Sierra Club, and the issue is whether an exemption to the Freedom of Information Act, better known to many as FOIA, protects against compelled disclosure of a federal agency's draft documents that concerned a proposed agency action that was later modified after an interagency consultation process. Sounds riveting. Next is Borden versus United States, and this is whether the use of force clause in the Armed Career Criminal Act encompasses crimes with a mens rea of mere recklessness. It seems the court can never get away from more Armed Career Criminal Act cases. They just decided one a couple weeks ago, and they've got another one coming up now. And then finally, the big news this week, California versus Texas. This is a challenge to the Affordable Care Act's individual mandate provision, which the Supreme Court previously upheld as a lawful exercise of Congress's taxing power. So Congress eliminated that tax penalty in the Tax Cuts and Jobs Act of 2017. And so this case, brought by private plaintiffs, Texas, and several other states, is asking the Supreme Court to declare that the individual mandate is unconstitutional and cannot be severed from the remainder of the law. So that case, all 3 of those cases will be argued in the next term.
Of course, the ACA case is a very big deal. The court was asked by California and the states on its side to add that case to this term, and the court denied that. So our general feeling in the press room was that the court and perhaps the chief did not want to have that issue in such a big term, but did turn around a few weeks later and grant it. And we're not sure when the court will hear this, but obviously all the briefing will be going on in the midst of the presidential election, and a decision, not likely till 2021.
Yeah, maybe it could end up being June of 2021.
Correct.
And this will be, I think, the sixth case stemming from the Affordable Care Act to come to the Supreme Court. So it is certainly the Full Employment Act for Supreme Court lawyers.
They need that.
Before we get to the arguments this week, I wanted to talk briefly about what happened between the Chief Justice and Senator Chuck Schumer. So speaking at a rally outside of the Supreme Court, after oral argument this week in the Louisiana abortion case, the Senate Minority Leader, Chuck Schumer, called out Justices Gorsuch and Kavanaugh by name, saying, quote, "You have released the whirlwind and you will pay the price. You won't know what hit you if you go forward with these awful decisions." So Chief Justice John Roberts issued a statement rebuking Schumer, and here's what he had to say. Justices know that criticism comes with the territory, but threatening statements of this sort from the highest levels of government are not only inappropriate, they are dangerous. All members of the court will continue to do their job without fear or favor from whatever quarter. And Senator Schumer, initially his office doubled down, saying that, the senator clearly meant that Republicans will pay a political price for putting Kavanaugh and Gorsuch on the court. This led to, many members of the Senate and people in the media and even the American Bar Association, which is not typically considered a bastion of conservatism, lambasting Schumer for his intimidation tactics. And then Thursday, Schumer took to the Senate floor, offering somewhat of a half apology. It kind of seemed like a sorry, not sorry to me. He said he's passionate about women's right to have an abortion, and Republicans are trying to take that away. And then he said, look, I'm from Brooklyn. I speak in strong language. And he said, I shouldn't have used the words that I did, but in no way was I making a threat. I never would do such a thing, and Leader McConnell knows that. He claims the reference to paying a price clearly means, the Republicans are going to pay a political price, and that Republicans are busy manufacturing outrage over these comments, and they know that. I think Senator Schumer should know better, and I think he really does know better. The rhetoric surrounding the court has become increasingly aggressive in recent years. Just consider Senator Whitehouse's amicus brief last fall in the gun case, where he told the court it needs to heal itself or it will face restructuring. So I didn't think Senator Schumer's apology was enough, and we really need politicians to be more careful in their language, because we shouldn't be threatening members of the Supreme Court.
Well, I don't have an opinion on that just because I cover these things, but I have some observations. Senator Schumer's explanation and his staff's explanation for his comments were directed to you, Justice Gorsuch, and you, Justice Kavanaugh. Didn't really square. But as he said today on the floor, or on Thursday on the floor, that he didn't word it maybe as he would have liked. Of course, some of his allies on the left are comparing his language with that of Brett Kavanaugh when he was a nominee and had come back to the Senate Judiciary Committee in the heat of his confirmation battle with some strong language. So I did wonder if, about the Chief Justice's response, whether it might have been better to just let these comments at an outdoor rally outside the court go. But I think Senator Schumer's comments did get quite a bit of attention, and the chief, who had responded to President Trump about a year ago, criticism of judges, then did not respond a couple weeks ago with regard to the president's comments on Justice Sotomayor and Justice Ginsburg. Perhaps, in the president's view, should not be ruling on his cases. I think maybe the Chief Justice said, all right, I'll respond to a Democratic leader's statements. I don't think he wants to respond to every one of the president's statements, because he'd be doing nothing but that.
Yeah, I think that's right, and I'm glad that the chief is admonishing all criticisms that are beyond the pale of the Supreme Court. Although I think there is something a little bit different about the president, putting aside whether Sotomayor and Ginsburg should recuse themselves in all cases involving President Trump or the administration, putting that aside, I think there is something different with suggesting they recuse and, threatening them and saying they're going to pay a price. And I recognize it was at a rally, but I think that Senator Schumer went too far. But turning to the big event, the main event, there were two big Supreme Court arguments this week. First up was Selah Law versus CFPB. By way of background, this case is challenging the structure of the Consumer Financial Protection Bureau, which Congress created in 2010. It has a single director appointed by the president who serves a 5-year term and can only be removed from office for inefficiency, neglect of duty, or malfeasance in office. So the structure of this new agency drew constitutional challenges almost immediately, and the argument is that the removal protections afforded to the director violate the president's power to remove subordinate officers. So, Mark, you were at the court. What were some of the highlights from the argument? Yeah,
so this argument would be a big deal in any week, although it's somewhat of special interest to law nerds in Washington who are concerned about separation of powers and the unitary executive and that sort of thing. And so it was the day before the big abortion case that we're going to get to. But you have a packed courtroom. You have Maureen Scalia, the wife of the late Justice Antonin Scalia, coming to court because 3 of his former clerks are arguing in the case, 3 of the 4. You have like Mick Mulvaney was there from the administration, the acting White House chief of staff, and also, in my view, a very well-argued case, lots of highlights and some fireworks. It's just one of those times you're sitting in the Supreme Court in an argument and you feel like you're just really learning at a constitutional seminar of the highest order.
Yeah, definitely. When you have people of the caliber of, Ken and Shanmugam and Noel Francisco and Paul Clement arguing together and against each other at different points depending on the arguments, it really is a masterclass in Supreme Court advocacy. So just your takeaways from the argument, you think it's looking bad for the CFPB, looking good for the CFPB?
It's looking somewhat good for the view of Selah Law and the administration. There are some differences there, but not, I think, as sweeping as some of the arguments that I think Cannon was maybe making about the whole Dodd-Frank Act having to be struck down.
Yeah.
For this. I think the administration's view of maybe this measure could be severed would maybe be the most likely to prevail. But maybe go into some of the highlights of that argument. And we did have, as you mentioned, Paul Clement, because the government had chosen not to defend the judgment below. Paul Clement, appointed by Justice Kagan as Circuit Justice for the Ninth Circuit, where this came from. Some might call it the Ninth Circus.
The Ninth Circus, yeah, that's appropriate.
Did a very good job in his brief, in his argument. He was trying to assure some of the conservative members of the court that there'd really be no sweeping effect to upholding this structure, and because questions were raised about, whether the president would even be able to fire cabinet members if this line of thinking prevailed. And he made a very interesting analogy. He said, in the current situation, you see people are trying to make a political football out of dealing with a pandemic disease. So maybe Congress decides, what makes sense, let's have the head of CDC be protected by for-cause removal because that'll make sure people get good advice and it doesn't become political. That's the kind of sensible decision that Congress has been making for over 100 years, end quote. Obviously a very salient kind of example to bring to the court. So I think that Justice Neil Gorsuch tangled with Paul Clement in this argument a bit. Justice Gorsuch is sometimes impatient with counsel who don't answer his question right away. Yeah. My colleague in the press room, Marcia Coyle, wrote a story this week. Just noticed how many times he'd say, I'd be grateful if you could answer that question or give us an answer.
Yeah.
He likes the word grateful. And some of my colleagues described Paul as being a bit taken aback. Paul Clement was making his 101st argument here. He just did his 100th last week. Mm-hmm. And I think he handled it pretty well, and he tried to respond to Justice Gorsuch. He more or less apologized for Justice Gorsuch's suggestion that he had disparaged to the Solicitor General with a little bit of a quip that Paul Clement had made. And of course, it went on, and there are 9 justices up there and 8 of them who were regularly asking questions, and it moves on. So.
Well, we'll see what happens. I bet this is going to be one where we won't see an opinion until maybe late May or maybe even into June. But turning to the second big argument of the week, the court heard argument in June Medical Services versus Russo. This is a challenge to Louisiana's law requiring abortion providers to have admitting privileges at a nearby hospital. So if this sounds familiar, that's because the court invalidated a similar Texas law in 2016 in the Whole Women's Health versus Hellerstedt case. In that case, the court found that the Texas law constituted an undue burden on women's access to abortion. But the court did not rule that laws requiring admitting privileges are per se unconstitutional. So an additional issue the court considered in June Medical Services is whether abortion providers should even be allowed to bring lawsuits asserting the rights of women to access abortions in the first place. So the argument here is that abortion providers don't have standing to litigate women's claims. Courts typically gloss over the standing inquiry in these types of cases, assuming doctors and clinics may assert women's claims under the third-party standing doctrine. So there was not a ton of discussion of this at the oral argument, although Justice Alito did ask a lot of questions, particularly of the lawyer for June Medical Services about this. He was the only conservative justice to ask about standing, and in particular, he wanted to know, if there's a conflict of interest between doctors and women. The lawyer for June Medical Services said that, since doctors are directly regulated, they should be able to sue asserting the women's claims, even where the challenged law, quote, in a sense, protected the third parties from the plaintiffs. Liz Murrill, who's the Louisiana Solicitor General, argued that abortion providers don't meet the rigorous rule for third-party standing, and the court should make them comply with the same rules as any other federal litigant. Ginsburg wanted to know how this case is different from some of the court's other third-party standing cases, such as probably the best-known Craig versus Boren from 1976, where the court allowed a beer seller to assert an equal protection claim to a state law barring the sale of 3.2% beer to men ages 18 to 21. So the Louisiana SG explained that in her view, Craig v. Boren is more like a mootness case because there had been an individual plaintiff in that case, but he had turned 21 while the case was pending, and the Supreme Court didn't see the point in waiting for another challenge. But she also pointed out that in Craig v. Boren, there wasn't a conflict of interest, whereas here you're dealing with a health and safety regulation, and there could be such a conflict. Jeff Wall from the Solicitor General of the United States office picked up on this thread later in the argument, pointing out that abortion providers most likely are going to want less regulation, and women presumably want qualified doctors treating them.
Can I say one thing
Yes.
about the third-party standing? Because obviously an abortion case raises a lot of profound issues when you get to the merits. Sitting in the press section during the argument, I won't say exactly who, but a colleague of mine who works for a legal publication, as this was going on for some time, just said, "Oh, I'm loving this." So,
much of the argument focused on the merits of the Louisiana law and the benefits and burdens of this law. That's particularly what the Chief Justice and Justice Kavanaugh wanted to know about, and they are seen as the key votes in this case. Roberts, of course, had sided with the liberal members of the court to grant a stay to June Medical Services earlier in this litigation. So the lawyer for the clinics for June Medical Services says there are no medical benefits to admitting privileges, but Louisiana can point to numerous instances of incompetence by doctors in Louisiana that motivated the state legislature to pass this law. So the SG also pointed out that this requirement is consistent with what the state requires of doctors that perform other kinds of procedures, whether in their office or at an ambulatory surgery center. The Louisiana SG explained that in addition to providing continuity of care by allowing doctors to treat their patients at a nearby hospital, it also serves as a bit of a quality control measure because hospitals conduct a much more thorough review of applicants for admitting privileges than a clinic's review in the course of hiring. She pointed out that June Medical Services, for example, had previously hired a radiologist and an ophthalmologist, and they had been trained to perform abortions. Looking to the burdens, Justice Kavanaugh asked, if all the doctors could get admitting privileges, would the law still be an undue burden on abortion access? And the lawyer for June Medical Services said, the law would have no benefit, but it would still be an undue burden. And the SG of Louisiana pointed out that, look, the doctors have been able to get privileges. But some of them have failed to make a good faith effort. She pointed out that, one doctor, for example, had applied to only 1 out of 9 hospitals in his area, even though a colleague of his was able to get privileges at one of the other 8 hospitals that he didn't apply to. Notably, Justice Gorsuch did not ask any questions. Justice Thomas didn't either, but that's pretty standard. So what were some of your insights?
So as you mentioned with Justice Gorsuch, this is really for Justice Kavanaugh, this is their first abortion rights case. Justice Gorsuch was on the court when it dealt with the California law involving advertising related to abortion centers and alternative centers. So he just sat and took it all in. And as you indicated, Justice Kavanaugh was quite active, and the Chief Justice only asking a few questions. So my sense that for many people on the court, for most of the others besides Gorsuch and Kavanaugh, although now people are wondering about where the Chief Justice might fall in this, but certainly the liberal bloc of the court seemed pretty solid in its views that it would probably hold to whole women's health, the case from a few years ago. I had a sense, from Justice Breyer, who was talking quite a bit about some of the third-party standing precedents that allowed doctors to assert the rights of women, and his discussion of the record. And there's all these doctors are referred to as Doe number 1, Doe number 2, and so forth. And just his general observation, sort of a sense of world weariness with the abortion issue, which obviously has been a contentious issue in this country for 40 years at least, kind of know where they're going to go. But we don't know, I think, how this case is going to come out at the end of the day yesterday, on an argument day, because we're just not sure where the Chief Justice is going to go. There are some people who've suggested he's, laying the groundwork for a narrow ruling, and then that in favor of of Louisiana and the Louisiana law. But we'll have to see.
Yeah, I think this will certainly be one of those rulings that will probably get the last week of June right before they hightail it out of the city for the summer. Well, speaking of Louisiana, I recently spoke with Elizabeth Murrill, who is the Solicitor General of the state. Welcome to SCOTUS 101.
Thanks for having me.
So you've spent most of your career working in government in Louisiana. You worked for Governor Jindal and in the state's Justice Department. So tell me about some of your experiences.
So oddly, I don't think I ever would have predicted this for myself, but I've worked in some capacity in government for most of my whole career. When I got out of law school, I clerked in federal court, and then I clerked in the state appellate court, and then I moved from there to the LSU Law School and stayed there for a while. Also practiced a lot and had private practice during that time. Managed to have 4 children during that time. And then I competed and was selected for this Supreme Court fellowship in 2007 and came to D.C. for a year. And when I came back, that's when I joined the Jindal administration. And so I've been kind of more active outside of academia and the court system. I've been more actively involved in state government legal issues for probably the last 10 years.
So you were appointed to be the first Solicitor General of Louisiana back in 2016. Although you weren't the first person to hold sort of this position, just the first one with that title. Friend of the podcast, Fifth Circuit Judge Kyle Duncan had served as the appellate chief of Louisiana, which had pretty much the same function.
Right. So
tell me about setting up your office, and are there any states that you've tried to model your office after, and what have been some of the highlights so far?
Well, the bright shining star for all of us is Texas. They have the big office. So, but NAG has a seminar every year, and so a lot of the Solicitor Generals from all over the country come together, both sides of the aisle, and we'll talk about our offices at that meeting. And so you get a good idea, I think, of how what different offices do, and a lot of our states handle work a little differently. Some states do all their state's habeas work, and some don't. And so a lot of times that dictates what the SG's office is going to be doing. So I looked at those things. I mean, I looked at, what are we doing? What are our needs? What's our budget look like? What do we want to be doing? I mean, initially when I first took over the role, I was also the civil division director. So I was kind of, wearing two hats. I moved from there I put the civil division hat aside and took the administrative director division hat and put that on and wore those two hats. And so now all I do is the SG work. But in the first 2 years, it was kind of dicey because I was doing a lot. We were trying to figure out how to build our office. But I was able to kind of look at how other people's offices were built, what size, based on the size of their state, and how much work did they have, what did we need. I mean, I'm still always looking to recruit, smart, capable people. And I've managed to find some super fantastic people. A couple of them are sitting right next to me. And so, I hired Scott St. John. He's fantastic. He works out in New Orleans. I've recently hired 2 assistant solicitor generals. They're fantastic. I have another deputy who came out of academia. She's great. My assistant, Lauren, I call her my air traffic controller. She's the other half of me. I couldn't do, half of the things that I do without her. So that's kind of our core group right now. We have a lot of work to do, so I'm always looking to find, good people. It's great work. We love what we do.
So as Solicitor General, you've had the opportunity to argue twice before the U.S. Supreme Court, and your third argument is coming up in a couple of weeks in early March. So tell me about your first Supreme Court argument.
McCoy versus Louisiana. So that was a really interesting case. And it came to us through one of the district attorney offices. And it was just an unusual situation. It arose from capital litigation, from a prosecution of someone in North Louisiana who had been charged with capital murder. And in the course of the defense of his case, his lawyer had conceded that he committed the crimes as a means of defending him from the ultimate penalty of death. So it's called a concession defense. It's kind of a well-known thing in defense, I think, capital defense circles. The unique thing about that case was that he did this over the objection of his client, and that made it very different from a case that had been decided 12 years earlier, and which was Florida v. Nixon, where the client didn't overtly object. And so really it was one of those cases where Justice Ginsburg wrote the opinion 12 years prior to McCoy and said, this is not that. And if that situation arises, it might be a different answer. And so McCoy, 12 years later, is that fact scenario or close to it. And so it presented, I think, the question more acutely. But it was an interesting thing because I was basically defending the state's conviction and the process, and the judge hadn't done anything wrong in our view. He had tried his best to protect the process and make sure that the defendant received due process. The prosecutors hadn't done anything wrong either. They were very solicitous, trying to make sure that everything was done right, because at the end of the day, they don't want if they get a conviction, they don't want it reversed.
Yeah, of course.
So, I found myself defending what the lawyer did, and he had particular reasons for doing what he did, but that was an interesting case.
So in your 2 arguments, you went toe-to-toe with some pretty formidable opponents, a former Solicitor General of the United States, Seth Waxman, and Stanford Law professor Jeffrey Fisher. So as a first-time and second-time advocate, was that intimidating, not only to be arguing before the Supreme Court, but up against these 2 people who had been there many times before?
Sure, yeah, it is. It definitely is. When I I was preparing for the argument, and I think Seth Waxman had, at that time, probably more now, had argued something like 40 cases, has done a lot of pro bono work in criminal cases. I had never met him before, but when I arrived at the Supreme Court for the day of the arguments, we're upstairs in the lawyer's lounge, and Scott Harris, the clerk, comes in, and he kind of looks to his left, and there's Paul Clement, And this isn't Paul Clement's first rodeo either. So Seth Waxman is on one side of me and Paul Clement's on the other side of me. And so Scott Harris kind of looks at me and says, "You're the only one that needs this speech." So he kind of gives me the speech for a first-time advocate and where I'm going to sit and when he's going to come and bring me in and what to do and when to stand up and all of those sort of fundamental things that they didn't need to know.
Yeah.
But he asked me at the time. He said, "Have we met before?" And I said, "I don't know if maybe because I was a fellow here a few years ago. It's probably 8 years ago, but I'm sure you wouldn't remember that." And so we just started chatting, and I think that I mentioned that my father was there. I thanked him for kind of helping to accommodate us on some guest seating for that argument, and that my father was here. And so Seth Waxman came over to me after that and started talking, talking with me and saying that his very first argument, his father was able to come and see him argue his very first case.
Yeah.
And he was very kind and it was great. Everybody that I've met and worked with on all of these cases has been so fantastic. I think there's just a lot of people who are invested in making sure that we all can put our best foot forward and do a good job in this type of advocacy. And I'm grateful to all of them for their help, even if they're on the other side.
Especially, yeah.
Yeah.
So have you developed any pre-argument rituals, or do you have any traditions? Do you have a pump-up jam to get yourself in the right headspace before an argument?
I don't really have one. I have a new pump-up video. So it's the LSU championship team hype video. It's great. If you haven't seen it, that's my new pump-up song. It's my pump-up video. It's a great hype video.
That's great.
So I listen to that. I listen to a wide variety of different music, but right now I think the kind of music that I want is music with no words. I have, you read a lot, you prepare a lot, you mood a lot. I think that sometimes you just want to have something that has no words.
Decompress.
Yeah.
Well, shifting gears a little bit, Louisiana is known for its unique legal system. Is it really that different from other states, though? You hear things about the Napoleonic codes and things like that, but since you're from Louisiana, educate us.
Well, okay, so first thing I can do is clarify that we do not follow the Napoleonic Code. We have our own code. We have the Louisiana Civil Code. There are other states that also have their own civil codes. Georgia has a civil code. We have a code of criminal procedure and a criminal code. I mean, we are a kind of a code-based system, and so the foundations of our legal system are based on a kind of Roman civil law foundation, and most of the time that really doesn't come out any differently than a common law system. I mean, we still we use a little bit different terminology, and probably my civil law systems professors would say, no, it's terribly different. And there are some nuances that make it kind of different. But and there are some of our laws that are very traceable back, all the way down the line to Spanish law or French law or the French Civil Code, because it was a model for our civil code. And so there are some of those things like that. But I mean, most of our legal principles are generally, you find something that correlates in the common law.
Thanks for clearing that up. So I want to return to something that you mentioned. So you spent a year up here in Washington at the working at the Supreme Court as a judicial fellow. So I read that you worked with the International Judicial Affairs Office. So I bet you met some interesting people in the course of that year. Can you tell me about that experience?
That was a fantastic experience. I worked closely with Mira Girari, who does this all of the time with the International Affairs team, and she works with the federal judges who are on the committee that do rule of law programs. And so they will travel around the world just explaining and working with emerging democracies. At the time that I was there, we would have teams that would come in from other countries to the FJC, and they would do tours. They would come in for lectures at the FJC, or they would go to the court. And one of my colleagues, who was a fellow at the court, would sometimes do the same thing that I would do at the FJC. But we would just give them briefings and we would talk about our legal system and why it was different and what was different about it. And they would tell us about their legal system. One of the interesting experiences that I had that year was meeting with the first 80 women judges appointed in Egypt.
Oh, wow.
So that was really fascinating. And so it was kind of interesting. And we had this big discussion afterward about how great it was that there were these women that had been appointed to be judges in Egypt. But at the same time, they even brought this up that they didn't have judicial independence. They were appointed by the executive. They could be fired by the executive. Ooh. And so, there were a lot of conversations like that during the year. It was really interesting to talk with other countries that were emerging democracies thinking about setting up their systems and what kind of factors come into play with, and a large part of that conversation a lot of the time was judicial independence was so important to be able to ultimately create the kind of balance that we have in our system.
So you also mentioned that you taught at LSU at the law school there for a number of years. What were some of your favorite classes to teach?
Well, the classes that I primarily taught were appellate advocacy and legal writing. And so I did that for almost 12 years. And it was a great experience. I mean, I've always loved to write, and I've always been a writer kind of at heart and an editor. And so, one of the things that you do teaching law students is not just how to do legal research and how to structure an argument, but you get the opportunity to work with some really smart, fun people in moot court practice and moot court competition. And that was probably one of the things that I really enjoyed the most was moot court coaching because they were self-selecting into this. They were just really, it wasn't a class they had to take. It was just something they were doing because they wanted to. So we would spend a lot of time practicing and then go travel with them to competitions and I got to do some things that were a little outside my ordinary comfort zone. I think I coached the Admiralty moot court team for 3 years.
Oh,
so go figure.
Well, you're in the Fifth Circuit. What's something that you wish you had known when you were just starting out in your legal career?
Well, I think there's two things. One, I think it's very sound advice that I received and that I followed to kind of have some purpose in what you do. I mean, it doesn't have to be – I always had some guiding sort of star. I knew when I was in law school that I wanted to clerk because I loved reading opinions. I loved the way they were written. I thought that would be really, really cool to work for a judge and to be able to draft opinions. And that I knew that was the very first thing that I wanted to do and I always felt like that was a great foundation. That's something I always tell my law clerks and interns. I always encourage them to clerk because it's such a great foundational experience to kind of begin your career. You get to practice, you get to write, you have to sort of discipline your thinking, discipline your writing, think about you're faced with different situations, and then you get to see advocacy. So whether you're doing that in a trial level clerkship or you're doing it in an appellate level clerkship or you're doing both, you still get some time to kind of see people advocating. You get to see good, you get to see bad, and you get to practice writing in a very disciplined way. So I think just skill development, that kind of focusing on building blocks, building skills, and thinking about becoming a better lawyer and a good and over time. It doesn't happen all at one time. And most of us when we get out of law school, we really don't know how to do anything. So it's you have a lot to learn when you get out and you pass the bar. It's a beginning, not an ending. And I think that being able to build your skills over time and recognizing that it really does take a long time to be good at something like this, that over time, the more you do something, the better you get at it. And that's the advice that I give to people. And of course, I love what I do. Every job I've ever had, I thought about, was there something about it that I would really like to do or really love about that job? If it was writing, if it was advocacy, if it was teaching, if it was there was something about it that I was going to be excited about. And I think that has given me some of a non-traditional career path.
So one final question, something I ask all guests at SCOTUS 101. If you could have a conversation with any Supreme Court justice, living or dead, who would you pick and what would you talk about?
So I have a very practical answer to this question. I mean,
Okay.
of all the Supreme Court justices, my answer is Justice Alito because it has more likelihood of actually occurring than having lunch with a dead Supreme Court justice. But if I could, I would love to go to lunch with Justice Alito. He's our circuit justice and really, my favorite Supreme Court justice. And I would love to go sit down and have lunch with him.
That'd be great. Well, thank you for joining me. We'll wrap up with a round of Supreme Trivia. Before They Were Justices edition. I'm going to try to stump my guest host, Mark Walsh.
Oh, okay.
Are you ready?
I'm ready.
Okay.
I don't remember how well I did the last time. I'm not super well, I don't think. But
Okay, first question. Before being appointed to the High Court, this future justice spent 2 summers in Sweden studying the country's civil procedure.
that would be Justice Ginsburg.
That is correct, and she learned Swedish and co-authored a book on the country's civil procedure. Okay, you're off to a great start. Second question. During college, this future justice apparently played a prank on one of his roommates by filling up their dorm's ice cube tray with salt so that when his roommate had his nightly scotch on the rocks, it was not a tasty treat.
Right, I don't know. I'm going to make a guess. I'll guess Justice Gorsuch.
No, it was actually Justice Alito, which really surprised me when I heard this, because that seems pretty unlike the bookish and kind of quiet justice who seems like he would have been sticking to his studies when he was in school. Okay, third question. In high school, it's rumored that this future justice was quite the Latin scholar, and he was able to translate the Aeneid side by side with his Latin teacher.
This is a current member of the court?
Yes.
Okay, I'll say the Chief Justice.
That is correct. And, you know, in addition to his expertise in Latin, he was involved in a number of extracurriculars, including playing Peppermint Patty in his school's production of You're a Good Man, Charlie Brown, since he went to an all-boys school. Okay.
Sorry that they didn't get that on video.
That would be something. Fourth question. This future justice has spent a lot of time outdoors, and he's actually a double black diamond skier.
Well, that, I think, is probably Justice Gorsuch.
That is correct. The Colorado native, Justice Gorsuch, loves skiing, and he talked at one point in his confirmation hearing about how he and his wife love to take their girls on backcountry skiing trips, and
That's right.
they're all very good at it. Okay, final question. In this future justice's high school yearbook photo, she was posed in a judge's robe with a gavel in hand.
Okay, what wasn't when you said high school yearbook photo that someone else came to mind immediately, as you might expect. Who was with a gavel in her hand?
And I think I've read somewhere that she also had the accolade of being most likely to be appointed to the Supreme Court.
Wow. Well, I'll say Justice Kagan.
That is correct.
Okay.
Yes. She had her eyes on the prize even when she was back in high school. Well, I think you did a great job.
Can I say something
Yes.
quick about gavels? Since they're quite the popular gift item in the Supreme Court gift shop. And if you find like some of the RBG toys, they come with her little lace gloves and jabot and a gavel. But the members of the court don't do a lot of gaveling on the bench. In fact, none at all. It's the marshal who gavels things. And yet, the chief got to use that little gavel in the Senate, not the normal one with a handle. But so it just amuses me sometimes when people are buying these gavels in the court gift shop.
That's great. Well, thank you so much for joining me. This was a lot of fun.
Thanks, Elizabeth. Happy to do it anytime.
Thanks for listening to SCOTUS 101. Be sure to subscribe on Spotify, iTunes, or wherever you listen to your podcasts, and please leave us a 5-star rating. Please follow us on Twitter and Instagram at SCOTUS 101, and you can email us at scotus101@heritage.org with questions, comments, or ideas for future episodes.
You've been listening to SCOTUS 101, brought to you by more than 500,000 members of the Heritage Foundation. Executive produced by Elizabeth Slattery. Sound designed by Lauren Evans, Thalia Rampersad, and Mark Guiney. For more information, visit heritage.org.